The Supreme Court of the United States can do something extraordinary. It can take a law passed by Congress, signed by the President, the elected will of the people, and erase it, declare it void, strike it dead. 9 unelected judges overruling the entire elected government. It is one of the most awesome powers in any democracy on earth. And here is what almost no one realizes. That power is not written in the Constitution. The court was never handed it. The court claimed it in 1803 in a quiet, clever ruling that grew out of nothing more than a batch of letters that were never delivered. This is the story of Marbury versus Madison, the case that invented judicial review and transformed the Supreme Court from the weakest branch of government into a genuine equal of the President and Congress. It is, in a sense, the case that gives every other case its power. One note before we begin: this is legal history and education, not legal advice. To understand it, we have to start with one of the ugliest political fights in early American history, the election of 1800. President John Adams and his Federalist Party lost badly to Thomas Jefferson. Power was about to change hands, and the Federalists were terrified. They were losing the presidency and Congress all at once. But there was one branch they could still hold on to if they moved fast: the courts. So in his final weeks, Adams and the outgoing Federalist Congress did something audacious. They passed a new law creating dozens of fresh judgeships, and Adams rushed to fill every one of them with loyal Federalists. He signed the appointments late into the night, right up to his last hours in office. History would give these last-minute appointees a nickname: the Midnight Judges. Among the smaller appointments was a man named William Marbury, named a Justice of the Peace for the District of Columbia. His commission, the official document making the job real, was signed by President Adams and sealed by the government. Everything was in order. There was just one final step left. Someone had to physically deliver it. And in the chaos of those last hours, Marbury's commission, along with several others, never went out the door. Then Jefferson took office. When he discovered the pile of last-minute Federalist commissions sitting undelivered, he was furious at the whole scheme to pack the courts. So he gave his new Secretary of State a simple instruction: do not deliver them, just let them sit. That Secretary of State, the man now refusing to hand over the commissions, was James Madison. And so the case got its name: Marbury demanding his job versus Madison refusing to give it. Marbury did something bold. He went straight to the Supreme Court itself and asked it to issue what's called a writ of mandamus, a court order commanding a government official to do his legal duty. In plain terms, Marbury asked the justices to order Madison to hand over the commission. He brought his case directly to the highest court in the land under a federal law called the Judiciary Act of 1789. Now here is where it gets delicious. The man who would decide this case, the new Chief Justice of the United States, was John Marshall. And Marshall was himself a Federalist, appointed by Adams in those very final days. Worse, in the previous administration, Marshall had actually been Adams's Secretary of State. He was, in fact, the official whose own office had failed to deliver Marbury's commission in the first place. By today's standards, he should have stepped aside. He did not. And Marshall faced a genuine trap, a no-win situation that could have crippled the young court forever. Think it through. If the court ordered Madison to deliver the commission, everyone knew Jefferson would simply ignore it. The court had no army, no police. An order the president openly defies is worthless, and the court would be exposed as powerless. But if the court did nothing, it would look like it was meekly surrendering to Jefferson. Either path made the Supreme Court look weak. So Marshall did something brilliant. Instead of answering the obvious question, does Marbury get his commission? He broke the case into 3 separate questions and answered them in a very deliberate order. First, did Marbury have a legal right to the commission? Second, if his right was violated, did the law give him a remedy? And third, The crucial one: was the Supreme Court the proper body to provide that remedy? On the first question, Marshall was blunt. Yes, Marbury had a clear right to his commission. It had been signed by the president and sealed by the government. The appointment was complete the moment it was signed. Withholding the document at that point, Marshall said, was not law. It was a violation of a man's legal rights. On the second question, Marshall went further. And this is where he quietly lectured the President of the United States. Where there is a legal right, he wrote, there must be a legal remedy. That is the very essence of a government of laws. The United States, he insisted, is a government of laws, not of men. No official, not even the executive branch, is above that law. By every normal measure, Marbury was entitled to a court order putting him in his office. So far, Marshall had handed Jefferson 2 stinging defeats on paper. Marbury had a right. Marbury deserved a remedy. The administration had acted lawlessly. Everyone reading along expected the obvious third step, an order commanding Madison to deliver the commission, and this is exactly where Marshall turned the entire case upside down. Because the third question was, could the Supreme Court itself issue that order? Marbury had come straight to the Supreme Court under that federal law, the Judiciary Act of 1789. One section of it, Section 13, appeared to give the court the power to issue writs of mandamus directly in cases brought to it in the first instance. Marbury was relying entirely on that section, and Marshall now took a hard look at it. He compared that law to the Constitution itself. Article 3 of the Constitution carefully lists the small set of cases the Supreme Court can hear directly, its original jurisdiction. Marbury's kind of case was not on that list, yet Section 13 of the Judiciary Act had tried to add to it, to hand the court a power the Constitution had not given. The law and the Constitution were in direct conflict, and that collision forced the deepest question of all, one no American court had ever squarely answered. When an ordinary law passed by Congress conflicts with the Constitution, which one wins? And just as importantly, whose job is it to decide? Marshall's answer would reshape American government forever. The Constitution, he declared, is the supreme law, superior to any ordinary act of the legislature. A law that contradicts the Constitution is therefore not valid law at all. In his most famous words, it is emphatically the province and duty of the judicial department to say what the law is. Interpreting the Constitution and refusing to enforce laws that violate it was the court's job. A law repugnant to the Constitution, Marshall wrote, is void. And so the Supreme Court struck down Section 13 of the Judiciary Act. The first time in history it declared an act of Congress unconstitutional, which meant the court had no power to issue Marbury's order after all. Marbury, the man whose name is on one of the most important cases in American law, lost. He never got his commission. He never became a justice of the peace. But look at what Marshall had actually done. He gave Jefferson nothing to defy. There was no order to deliver any commission, so there was nothing for the president to ignore or resist. Jefferson technically won the case, and yet, in the very act of losing, Marshall had claimed for the Supreme Court a power infinitely greater than one man's job. The power to declare the laws of Congress unconstitutional. He surrendered a pawn and captured the board. He lost the battle and won the war. And notice the most remarkable thing of all. Nowhere does the Constitution actually say the Supreme Court has this power. The words judicial review appear nowhere in the document. Marshall reasoned it into existence, argued that it followed naturally from the nature of a written constitution. The single greatest power of the American judiciary was not granted to the court. It was claimed by the court, and the claim simply held. Before Marbury, the Supreme Court had been widely seen as the weakest branch, an afterthought next to the President and Congress. After Marbury, it was something new, a true check on the other two, with the authority to tell the most powerful people in the country that what they had done violated the nation's highest law. The third branch of government had finally found its teeth. And that power did not stay in 1803. It became the engine of nearly everything the court has done since. Every time the Supreme Court strikes down a law, every time it decides what your rights truly are, the warning that must be read at your arrest, the lawyer the state must give you, the privacy the government must respect, it is using the exact power that Marshall conjured out of a dispute over undelivered letters. Marbury is the case standing quietly behind all the others. It is also, to this day, deeply contested. Because think about what judicial review really means. A handful of unelected judges, appointed for life, can overrule laws passed by the people's elected representatives. To its defenders, that is the essential safeguard, the thing that keeps even a popular majority from trampling the Constitution. To its critics, it is judges seizing the last word over a democracy. Every modern fight over the court's power and legitimacy traces straight back to this 1803 decision. But that tension is, in a way, the point. Marbury answered the question a written constitution cannot avoid. A constitution that no one can enforce is just a piece of paper. By making itself the enforcer, the court turned the Constitution from a statement of ideals into actual, binding law. It made real the promise of a government of laws and not of men. So the next time you hear that the Supreme Court has struck down a law or upheld a right against the government, remember where that power came from. Not from the Constitution's text, not from Congress, from a Chief Justice in 1803, boxed into a corner over a commission that was never delivered, who found a way to lose a small case and win an enormous power. With Miranda, with Gideon, with Katz, and now with Marbury, the case that stands behind them all, you can see the same quiet project, a country deciding, one ruling at a time, what its Constitution truly means. If that's the kind of thing you want to understand more deeply, consider subscribing. We take one landmark case at a time, and we try to get it right. Thank you for watching, and remember, this video is for education and history. It is not legal advice.